Hello and welcome students to Swadharma IAS Academy. Today we are going to conduct a really comprehensive deep dive into a topic that's been all over the headlines. It's causing a lot of shouting in TV studios, a lot of confusion, but for you as a serious UPSC aspirant, confusion really isn't an option. Precision is everything. We are of course discussing the removal motion against the Lok Sabha Speaker Mr. Om Birla. This topic sits right at the intersection of, well, high-voltage politics and very technical constitutional law. Before we jump into our deep dive, just a quick reminder for all of you listening right now. Watch till the end for complete conceptual clarity, and please don't forget to like, share, and subscribe to Swadharma IAS Academy.
Thank you, sir. It's genuinely good to be here because I've been following this closely in the papers, the op-eds, and honestly, the terminology is, well, it's all over the place. One headline says, impeachment of the speaker. Another one calls it a no-confidence motion against the speaker. And then a third one, a more careful one, talks about a resolution. It's genuinely confusing. I'm really hoping today we can strip all of that away and just look at what the Constitution actually says.
That is precisely our mission today. And that confusion you're feeling, that is exactly where the examiner will try to exploit a gap in your knowledge, especially in the prelims. If you fall for that impeachment trap, you lose marks. Simple as that. So our agenda is very specific. We are not here to debate the politics. Whether the speaker was right or wrong in his rulings, that's a matter for political pundits. Our job is to understand the process. We'll look at the context, of course, why this was triggered. But more importantly, we are going to dissect Articles 93, 94, and 96 of the Constitution. We'll demystify this concept of effective majority, which is, a very high-yield topic for GS Paper 2. And then we'll look at historical precedents to really build that mains-oriented critical analysis of the Speaker's office.
That sounds comprehensive. I think, sir, for the benefit of everyone listening, especially for those who might have missed the specifics in the deluge of news, we should probably start right at the beginning, the context. Why now? I mean, we've seen disruptions in Parliament before. Walkouts are common. What was the specific trigger that led 118 opposition members to actually sign a notice and submit it to the Secretariat?
Right, and it wasn't a single event. That's the first thing to understand. It was more like a culmination of grievances that really just reached a boiling point during this budget session. You should think of it like a pressure cooker situation. The immediate trigger, the spark that lit the fuse, they could be traced back to the motion of thanks on the President's address. Now, as you know, the motion of thanks is a foundational parliamentary convention. It's the formal opportunity for MPs to debate government policies. But on February 2nd, the leader of the opposition, Mr. Rahul Gandhi, he attempted to quote from the unpublished memoirs of the former Army Chief, General M.M. Narayan. And this was regarding the clashes with China and the Agni-Path scheme.
Right, I remember seeing that on the news. The Speaker stopped him, didn't he? It caused a huge uproar.
He did. The Speaker intervened and stopped the quote from being placed on record. Now, this is where we need to be really technical. He didn't just say, stop talking. He invoked specific rules. The argument from the chair was based on Rule 352 and Rule 349 of the Rules of Procedure, and the core argument was that you cannot quote from an unpublished book, especially one by a high-ranking official like the Army Chief, without the ability to authenticate the text. The government's stance was that since the book hadn't received the necessary clearance or even been published, quoting it in the House was procedurally incorrect.
Okay, so the chair's position was essentially that you can't just stand up, wave a piece of paper, and claim the general said this, because if it turns out to be false or misquoted, the privileges of the House are breached. Is that the idea?
That's the idea, exactly. The House demands authenticity. You have to remember, if you place a quote on the record of Parliament, it becomes a permanent part of the nation's history. It's an official document. The Speaker's role, in theory, is to ensure that the record is factually accurate and procedurally sound. However, the opposition, well, they viewed this very differently. They didn't see it as quality control. They saw it as censorship. They argued that the chair was actively silencing a critical voice on foreign policy and national security, all under the guise of, procedural technicalities.
So the allegation is about more than just mic management then. It must be deeper. Because just stopping one quote seems like a pretty thin ground for a full-blown removal motion.
It goes much, much deeper. That incident on the 2nd was just the spark. The fuel had been accumulating for a long, long time. The core grievance, if you had to boil it down to one phrase, is a violation of the spirit of neutrality. You see, after that incident, there was another flashpoint just 2 days later, on February 4th. And this is where the opposition claims that what they call asymmetric warfare is being waged in the House. A BJP MP, Nishikant Dubey, was allowed to speak, and during his speech, he critiqued former prime ministers and was even displaying books to support his arguments.
I see. So the opposition's question becomes, why was MP Dubey allowed to show a book and criticize past leaders, but our leader was stopped from quoting a book to criticize current policies?
Precisely. It's a direct comparison of how the rules are applied to the opposition benches versus the Treasury benches. The opposition's contention is that while their members are frequently stopped, or their words are expunged, or they're even suspended for disruptions, and you'll remember the mass suspension of members in the previous session, the members on the government side are allowed significantly more leeway. They're arguing that the referee is wearing the jersey of one of the teams. That is a very serious charge to make against the office of the Speaker. And I suppose the final straw was the issue with the Prime Minister's speech. Yes, that was the event that really sealed the decision to move the motion. Typically, as a matter of convention, the Prime Minister replies to the motion of thanks in the Lok Sabha. It's the highlight of the session. But in this case, the Speaker advised the Prime Minister not to reply in the Lok Sabha.
Why would the Speaker do that? Isn't it the Prime Minister's privilege and arguably his duty to address the House of the People?
Well, the Speaker cited severe security concerns. He stated he had received information about the likelihood of massive disruption, perhaps even a physical threat. He argued that there was a risk of such unruliness that the dignity of the office of the Prime Minister would be compromised. So as a result, the Prime Minister gave his reply in the Rajya Sabha instead.
And how did the opposition react to that advice?
Poorly, to say the least. They were furious. The opposition characterized this advice from the Speaker as providing an escape route for the Prime Minister to avoid tough questions. They even turned the threat assessment as false and defamatory to the opposition MPs. Their argument was that by preventing the head of government from speaking in the lower house, the Speaker was actually undermining the dignity of the House itself. They argued his job is to maintain order so that the PM can speak, not to tell the PM to run away to the upper house.
Wow. That is a heavy accusation. So essentially they're framing this as the Speaker acting not as a neutral arbiter, but as a protector of the government.
That is the essence of the allegation, and that is why those 118 members signed and submitted that notice. But we must pause here for a quick reality check. We are students of polity, yes, but we must also understand the numbers. In a parliamentary democracy, numbers are the ultimate currency. The ruling NDA has over 293 members. The collective opposition has significantly less than the majority mark needed to pass this motion. So strictly speaking, this motion has almost zero chance of actually removing Mr. Om Birla from his office.
So if it's going to fail, and they know it's going to fail, why even do it? Is it just political theater?
Yeah.
Or a waste of Parliament's valuable time?
It's not theater in the frigilous sense. In political science, we call it symbolic politics, but that doesn't mean it's useless. It is a formal parliamentary tool to register dissent. By forcing a debate on the removal of the Speaker, the opposition puts the Speaker's conduct under official scrutiny. It forces the entire House to discuss the neutrality of the chair. It exerts what we call moral pressure. It's a way of placing their grievances on the official, permanent record of Parliament for history to judge, and forces the Speaker himself to stand up and defend his neutrality, which might, in theory at least, make him more cautious in the future.
That makes perfect sense. It's about the narrative and using the check and balance mechanism, even if the final execution is destined to fail arithmetically. But sir, let's please go back to my first question, the terminology. I saw a headline that said, "Opposition moves to impeach Om Birla." As a UPSC aspirant, that word impeach it set off alarm bells in my head.
And your alarm bells were absolutely correct to go off. This is where you must distinguish yourself from a casual newsreader. In the Indian Constitution, the word impeachment is a term of art. It is not a loose synonym for firing someone or removing someone. It is reserved exclusively, and I mean exclusively, for one single office. Do you know which one?
That would be Article 61, the President of India.
Spot on. Article 61 deals with the procedure for impeachment of the President. The procedure is incredibly difficult, requiring a 2/3 majority of the total strength of both houses. It is the hardest removal process in our entire Constitution. Now, for judges of the Supreme Court and High Courts, the CAG, the CEC, the Constitution uses the word removal. But the process for them mimics impeachment because it also requires a special majority in both houses. But for the Speaker, the Constitution is very specific. It is strictly removal. Using the word impeachment for the Speaker in your mains answer would be a grave technical error. It shows the examiner you don't know the difference between Article 61 and Article 94.
And what about the other term I saw in no confidence motion?
Also completely incorrect. A no-confidence motion falls under Article 75 and is elaborated in Rule 198 of the Lok Sabha rules. It is directed against the entire Council of Ministers, the government. If a no-confidence motion passes, the government falls. The Prime Minister and the entire Council must resign. This motion against the Speaker is a resolution for removal under Article 94, Clause C. If this passes, the government does not fall. The Prime Minister remains. Only the Speaker loses his office. These distinctions are the bread and butter of prelims questions. You simply cannot afford to mix them up.
Okay, so it's a removal resolution. That's the correct term. Let's get into the constitutional provisions themselves then. Where does the Speaker's office come from, and how does this removal process actually work textually? I want to be able to visualize the article.
Let's do that. Let's open our mental copy of the Constitution to Part 5, Chapter 2, Parliament. Article 93 is the starting point. It's very simple but very important. It states that the House of the People shall, and note that word shall, choose 2 members of the House to be respectively Speaker and Deputy Speaker. The word shall makes it mandatory. It's not optional. The House must have these officers.
Sir, a quick doubt here on the election dates. This is often a trap in test series and mock papers. Who fixes the date for the election of the Speaker and Deputy Speaker?
I am glad you brought that up. It is a classic trap for the unwary. For the election of the Speaker, the date is fixed by the President of India. The President appoints the pro tem Speaker, who swears in the new members, and then the election of the permanent Speaker happens on a date that the President decides. However, once the Speaker is elected and is in the chair, the date for the election of the Deputy Speaker is fixed by the Speaker themselves.
Right. President for the Speaker, Speaker for the Deputy Speaker. Got it. That's a very clear distinction.
Now, let's move to the core of today's deep dive, Article 94. This article deals with the vacation, resignation, and removal of the Speaker and Deputy Speaker. Specifically, we need to focus on Article 94, Clause. It lays down the exact condition for removal. It says a Speaker may be removed from his office by a resolution of the House of the People passed by a majority of all the then members of the House.
All the then members? That phrase sounds incredibly specific. It doesn't just say a majority of the House or a majority of those present and voting.
Exactly. The framers chose their words with extreme care. And before we get to the mathematics of what then members means, there's a very important proviso attached to this article we must look at. The proviso states that no resolution for this purpose shall be moved unless at least 14 days' notice has been given of the intention to move the resolution.
Why 14 days? Why that specific number? Why can't the opposition just move it tomorrow if they're angry?
It stems from the principles of natural justice. The office of the Speaker is a high constitutional authority. You cannot ambush the office holder. The Speaker must have adequate time to prepare his defense, to understand the specific charges that have been levied against him, and to rally support among the members of the House. It ensures the process is deliberate and considered, not impulsive or reactionary. You don't want a situation where a Speaker makes a tough ruling at 11:00 a.m. and is removed by an angry mob of MPs at 12:00 p.m. That would destroy the stability of the House. This cooling-off period is essential.
Okay, so the notice has been given by the 118 members. That 14-day clock starts ticking. But let's go back to that crucial phrase, majority of all the then members. Is this what we technically call an effective majority?
Yes. This is exactly what we call an effective majority. And this is where many, many students get confused between absolute majority, simple majority, and effective majority. Article 94C requires an effective majority. We need to understand the logic behind why the Constitution framers chose this specific type of majority. They didn't want the removal of the Speaker to be as hard as the impeachment of the President, which needs a special majority, but they also didn't want it to be as easy as passing a normal bill, which only needs a simple majority. They wanted a middle path that provided security of tenure, but not complete immunity.
Could we walk through the calculation? I find that looking at the actual numbers really helps the concept stick. Can we use the current House as a hypothetical example?
Certainly. Let's use the blackboard method here. Just visualize the numbers for the Lok Sabha. First, we start with the total sanctioned strength of the Lok Sabha. At present, that is 543 members. Now, the phrase, all the then members, implies that we must look at the actual living qualified membership of the House at that specific moment in time. So from the total strength, we must subtract any and all vacancies. Vacancies can occur due to death, resignation, or disqualification under the 10th schedule. So the formula is effective strength, total strength, 543 vacancies.
Okay. So For argument's sake, let's say 3 MPs have passed away and another 10 have resigned to become chief ministers or for other personal reasons. That gives us 13 vacancies.
Correct. So 543 minus 13 gives us an effective strength of 530. Now, for an effective majority, you need more than 50% of this number of the effective strength. So 530 divided by 2 is 265. You need more than half, so you need one more. The required number to pass the resolution and remove the speaker in this hypothetical scenario is 266.
And this is fundamentally different from a simple majority.
Oh, vastly different. This is the crucial concept you must grasp. A simple majority is based on members present and voting. Imagine that on the day of the vote, out of our 530 members with effective strength, only 300 actually show up to the House. Maybe the others are boycotting or they're sick or traveling for constituency work. If it were a simple majority like for an ordinary bill or a no-confidence motion, you would only need 151 votes to pass it. That's half of 300 plus 1. But for the speaker's removal, it doesn't matter how many show up. You must hit that magic number derived from the effective strength. You still need 266 votes.
So let me get this straight. If only 260 members show up to Parliament that day, and every single one of them, 260 to 0, votes to remove the speaker, the motion still fails.
Exactly. Even with a unanimous vote of 260 to 0 against the speaker, he stays in his chair, because 260 is less than the effective majority threshold of 266. This highlights the security of tenure built into the office. It ensures that a speaker cannot be removed by a coincidence of low attendance or a snap vote. You need the demonstrable will of the majority of the entire functioning House, not just the majority of who happened to be in the room that day.
That makes the bar significantly higher for the opposition. They can't just rely on surprising the government. They have to ensure their own full attendance and then some.
Yes. And as we discussed, currently, the opposition numbers are roughly in the 230-240 range. Even if every single opposition MP shows up and votes in favor, they are mathematically well short of the roughly 270 mark needed for an effective majority in the current House. This just reinforces the point we made earlier. This is a symbolic battle, not an arithmetic one.
Understood. Now, let's talk about the day of the battle itself, the procedure in the House. So, the 118 members have submitted the notice. The 14-day period is over. Does the House then automatically begin debating it? Or is there another procedural hurdle?
There is indeed another hurdle, a very important one. The submission of the notice to the Secretary General is just the first step. After the 14 days expire, the motion must be formally admitted by the House. This part is governed by Rules 200 to 202 of the Lok Sabha Rules of Procedure. The motion needs the leave of the House to be discussed. The member who submitted the notice will stand up and formally ask for leave to move the motion. The presiding officer will then ask all those in favor of granting leave to rise in their seats.
Is there a quorum for this? Like, how many people need to stand up for the leave to be granted?
Yes, there's a specific number. At least 50 members must rise in their places in support. This acts as a filter to prevent frivolous or vexatious motions from wasting the House's time. If fewer than 50 members stand up, the motion is killed right there and then. It doesn't even proceed to the discussion stage. Now, in this specific case, 118 members signed the notice. So assuming they don't change their minds, getting 50 to stand up shouldn't be a problem. But you can imagine, in a very fragmented parliament, this rule of 50 can be a significant barrier.
Okay, so the leave is granted. The 50 members stand up. Now the discussion starts. Here is my biggest doubt, sir, and I think this is where the constitutional drama really peaks. We are discussing the removal of Mr. Umbrella. Can Mr. Umbrella sit in that big speaker's chair and preside over the discussion about his own removal? That just seems like a massive conflict of interest.
You're thinking like a lawyer, which is good. The Constitution foresaw this exact problem. It's addressed head-on in Article 96. Article 96, Clause 1, clearly states that at any sitting of the House of the People, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker shall not preside.
Shall not preside. That's very emphatic. Okay, so who does? The Deputy Speaker would be next in line, I assume.
Ideally, yes. The constitutional hierarchy dictates that the Deputy Speaker takes the chair in the Speaker's absence. But here is where we hit a massive and I would say quite disturbing constitutional anomaly. The current Lok Sabha, like the 17th Lok Sabha before it, does not have a deputy speaker. The post has been vacant since 2019.
That's right. I'd forgotten about that. It's been a major point of criticism from legal experts. The Constitution says she'll choose a deputy speaker using that mandatory language, but they just haven't. So if there is no deputy speaker and the speaker can't sit there, who presides over the chaos?
This brings us to a procedural device called the panel of chairpersons. At the start of each term, the speaker nominates up to 10 senior members to this panel. Their job is to preside when both the Speaker and the Deputy Speaker are absent. So in this scenario, one of the members from the panel of chairpersons would be called upon to take the chair and oversee the removal proceedings against Mr. Burla.
But sir, wait a minute, let me play devil's advocate here. If the Speaker himself appoints the panel of chairpersons, isn't there still a lingering conflict of interest? If I am facing removal and the person who will act as the judge is chosen from a list that I myself created, isn't that systemically problematic?
You have hit the constitutional nail on the head. This is precisely why the vacancy of the Deputy Speaker's office is so critical and so damaging. The Deputy Speaker is elected by the House, and by long-standing convention, that post usually went to the opposition. This gives the office holder independent legitimacy. The panel of chairpersons, on the other hand, is nominated by the Speaker. So yes, if a panel member presides, the opposition could very well argue that the presiding officer is still, in a way, an appointee of the very man on trial. This is why the Deputy Speaker vacuum is not just a procedural delay, it's a structural flaw that weakens the perceived fairness of the removal process itself.
That is a fascinating procedural twist. It really highlights how ignoring one part of the Constitution, Article 93, choosing a deputy speaker, can break the machinery of another part, in this case, Article 96.
Absolutely. It's a constitutional domino effect. One convention falls, and it weakens the structure down the line.
So let's proceed. Mr. Burla steps down from the chair. A panel member takes over. Where does Mr. Burla go? Does he sit in the benches? And can he say anything? Or must he sit silently while members criticize him?
He sits in the benches of the House, likely on the Treasury side, as he is an MP of the ruling party. And no, he does not have to be silent. Article 96, Clause 2, grants him significant rights during this proceeding. First, he has the right to speak. He can stand up and defend himself against the allegations. He can explain his rulings and justify his conduct. Second, he has the right to participate in the proceedings just like any other member. And third, and this is the most important key word for your prelims, he has the right to vote in the first instance.
First instance. Okay, let's unpack that phrase. Normally, the speaker only gets a vote when there's a tie, correct? The casting vote.
Correct. Under normal circumstances, governed by Article 100, the speaker acts as a neutral umpire. He does not vote in the daily business of the House. He only exercises his vote to break a deadlock. This is called a casting vote. But when he is facing removal, he effectively steps down from the umpire's chair. He becomes an ordinary member for that duration. The Constitution makers argued that since he represents a constituency quota in Rajasthan for Mr. Burla, his constituents shouldn't be voiceless just because their MP is the Speaker. So he regains his right to vote just like any other MP, which means voting in the first instance.
So he votes along with everyone else, but what if there is a tie? Let's say the vote is 265 for removal and 265 against removal. What happens then?
In that very specific scenario, the motion fails. Why? Because the Speaker, having already voted as an ordinary member, cannot vote again to break the tie. He loses his casting vote. The Constitution is explicit on this. He's entitled to vote in the first instance, but not in the case of inequality of votes.
That is brilliant logic. It's perfectly balanced. He trades his special casting vote for a normal ordinary vote because he is now a party to the dispute, not the judge.
Precisely. It preserves the principle that you cannot be a judge in your own cause, but it also ensures you don't lose your fundamental representative rights as a member of Parliament. It's a delicate balance between his role as an MP and his role as a constitutional authority.
So let's assume the debate happens. He defends himself. They vote. And as we've already established, the numbers are with the NDA, so the motion is soundly defeated. He goes back to the chair. Has this ever happened before? Or is Mr. Burla the first speaker to face this kind of motion?
He is certainly not the first to face the heat, though it's important to remember that no speaker has ever been successfully removed in the history of independent India. We have very clear historical precedents that you can and should quote in a mains answer about the challenges to the office of the Speaker. Okay. The very first instance was way back in 1954 against the first Speaker of the Lok Sabha, the Venerable G.V. Mavalankar.
Even Mavalankar. He's called the father of the Lok Sabha.
Yes, even him. The opposition at the time, which included stalwarts of the freedom movement, felt that Mavalankar was granting too much priority to government business and stifling the opposition's voice. The arguments were almost identical to the arguments you hear today. They moved a resolution. It was debated on December 18, 1954. Mavalankar defended himself with great dignity on the floor of the House, arguing that the Speaker's primary duty is to facilitate the government's legislative business while simultaneously protecting the rights of the minority to be heard. The motion was, of course, rejected, but the fact that it happened established the principle that the Speaker is not immune from scrutiny.
Who else faced such a motion?
In 1966, a motion was brought against Speaker Sardar Hukum Singh. Again, it was debated but ultimately failed. Then in 1987, there was a very famous incident involving Speaker Balram Jakhar. The motion was moved by Somnath Chatterjee, who ironically later became one of our most respected speakers himself. The opposition at that time alleged that Jakhar had been biased in delaying certain crucial debates. That motion was not even admitted. So while the office is high and respected, it is not immune to the friction of politics. It seems every few decades, when the political temperature rises, the speaker becomes the lightning rod for opposition frustration.
It really does seem like a recurring theme. Every 20 years or so, the opposition feels the speaker is biased. This brings me to a more structural question, sir. Why does this keep happening? Is it just the nature of politics, or is there a fundamental flaw in how we've designed the post in India?
That is the perfect mains-oriented question we need to address. This is where you elevate your answer from just describing what is to analyzing what should be. The recurrence of these allegations points to a structural paradox in the Indian parliamentary system. In India, the speaker contests the election on a party ticket, almost always the ruling party. He retains his party membership even after being elected speaker. While they're expected to be neutral, the moment they sit in the chair, they're expected to somehow cut the umbilical cord with their political past. It's a huge ask. It requires a superhuman level of compartmentalization, and the opposition naturally suspects that the party man is still alive and well inside the speaker.
How do other mature democracies handle this? I've heard the UK system is fundamentally different.
It is, and it's the gold standard for comparison in any mains answer on this topic. The British House of Commons operates on a powerful convention known as once a speaker, always a speaker.
Yeah.
In the UK, when a member of parliament is elected speaker, they formally and publicly resign from their political party. They sever all ties. They become, for all intents and purposes, a political orphan. Furthermore, and this is the most crucial part, in the next general election, the major political parties, Conservative, Labour, etc., do not field candidates against the speaker in his or her constituency. The speaker is traditionally returned to parliament unopposed.
That is a huge difference, because in India, the speaker knows that in 5 years, he has to go back to the voters. He needs his party's ticket to contest. He probably needs the prime minister to campaign for him in his constituency.
Exactly. You've nailed it. In India, the speaker's future political survival is intrinsically linked to the leadership of his party. This creates an inherent, if subconscious, structural conflict of interest. Even if a speaker genuinely wants to be completely neutral, the system exerts a constant pressure on him to be partisan to secure his own political future. In the UK, since the speaker's seat is guaranteed and he has no party affiliation, he can afford to be ruthlessly neutral, even against a powerful prime minister from his former party.
Have any committees in India recommended that we adopt this British model?
Oh, yes. The Page Committee and various other parliamentary reforms committees have strongly recommended that India should adopt the British model to ensure the speaker's impartiality. But political parties in India, and this includes both BJP and Congress when they are in power, have never reached a consensus on this. They seem to prefer having a friendly speaker when they hold the majority.
And I suppose the continued vacancy of the deputy speaker position just adds fuel to this fire of perceived bias.
It absolutely does. It removes the only institutional safety valve. If we had a deputy speaker from the opposition, as was the long-standing convention until 2014, the opposition would feel they have a stake, a voice, in the day-to-day running of the House. By keeping that post vacant, the ruling party effectively monopolizes the chair and its authority. This reinforces the narrative of exclusion, which leads to frustration, which leads to disruption, which leads to suspension, and finally, it leads to a last resort measure like this removal motion.
It's a vicious cycle.
It is a completely self-perpetuating vicious cycle. And that is why, even though this removal motion is numerically doomed to fail, it serves a vital constitutional function. It shines a bright, uncomfortable light on these cracks in our parliamentary edifice. It forces all of us, as citizens and students of the Constitution, to ask, are our institutions functioning as the framers intended, or are we just adhering to the letter of the law while completely violating its spirit?
So for the exam, the key takeaway shouldn't be just the vote count. It should be the lack of a deputy speaker and the structural bias issues that lead to such motions.
Absolutely. For prelims, you focus on the mechanics. Article 94C, effective majority, 14 days notice. Article 96, presiding rules, and the first instance vote. For mains, you focus on the deeper analysis, the conflict between party affiliation and neutrality, the comparison with the British model, and the erosion of healthy parliamentary conventions, like the timely election of a deputy speaker.
Sir, before we conclude, could you please summarize the concept of effective majority one last time? I just want to make sure I have the definition locked down perfectly.
Of course. Let's etch this into your memory. Effective majority is the majority of the effective strength of the House. And effective strength is simply the total sanctioned strength minus any vacancies at that time. So the formula is effective majority equals total strength vacancies divided by 2 plus 1. And remember, it is used for 3 specific removals in the Indian system. 1, the removal of the Speaker and Deputy Speaker of the Lok Sabha and their counterparts in state assemblies. And 2, the removal of the Vice President of India, which requires an effective majority in the Rajya Sabha. Keep that list handy. It's a favorite for match the following type questions in prelims.
Thank you, sir. That is crystal clear now. And just to reiterate one final point, the Speaker does not vacate his office when the Lok Sabha is dissolved, correct?
That's correct. Another crucial point for prelims. Under the proviso to Article 94, whenever the Lok Sabha is dissolved, the Speaker does not vacate his office immediately. He continues to hold office until immediately before the first meeting of the new Lok Sabha after the election. This is to ensure there is never a vacuum in the leadership of the House as an institution. The office is perpetual even if the members change.
So Mr. Om Birla, or whoever is the Speaker, essentially holds the fort until the pro tem Speaker is appointed and the new House is assembled.
Exactly right. The continuity of the Republic is maintained through these thoughtful constitutional provisions.
This has been incredibly helpful, sir. I feel much more confident distinguishing between the media noise and the actual examinable polity concepts now.
That is the goal. We've covered the context of the Narrowvein book and the PM's speech. We've dismantled the trap of impeachment terminology. We've done the math of effective majority, dissected the procedure involving the panel of chairpersons, and we've reviewed the historical precedents from Mavalankar to Jocker. To leave you with a final provocative thought to mull over, the Speaker is often called the conscience of the House. In a democracy, the majority has the right to rule, but the minority has the inalienable right to be heard. When the numbers in the House are overwhelmingly in favor of one side, does the conscience of the House have a greater, more profound duty to protect that minority voice? This removal motion, regardless of its success or failure, is ultimately a plea for that protection. It is a reminder to the institution that the chair belongs to the House, not to any single party. We hope this deep dive has cleared all your doubts regarding the removal of the Speaker. Watch till the end for complete conceptual clarity, and don't forget to like, share, and subscribe to Swadharma IAS Academy. Thank you for listening, and keep studying hard.